If you understand the importance of properly structuring a letter of intent or term sheet, you have a huge advantage over the other side in any business deal. LOIs and term sheets are the first written description of major business terms in any deal. And we have right in front of us a copy of a letter of intent for a simple commercial real estate deal. However, you'll see LOIs and term sheets in all sorts of deals: acquisitions of stock or other assets, mergers, real estate purchases, leases, joint ventures, business and other commercial transactions, supply agreements, and service agreements, to name a few. Okay, guys, the example letter of intent we have here in front of us is based on a deal that I recently closed. And you'll see here it's on my letterhead. Generally, letters of intent don't have to come from an attorney, but you certainly would want your attorney to take a look at it before it goes out. And you'll see here it's to the actual seller of the property, and it's for purchase of 15 Hunter Boulevard, Springfield Township. The first paragraph here in the letter of intent is basically just an introduction. Please be advised that this firm represents Fortune Investment, the proposed buyer, regarding the above referenced property, and this letter of intent is based on purchasing under these specific terms. And the first important term, of course, is what is the price? And in this case, it's $1,888,000. Second paragraph here is contingencies. First, we see a mortgage contingency stating that the buyer is relying upon a mortgage and being granted a mortgage to actually close on the deal. And if he can't get a mortgage, then he can essentially, or she can, terminate the deal and get the deposit back. Due diligence. Here's a big one. In most more complicated commercial deals, whether they be, again, purchase of assets or purchase of stock or purchase of real estate, the buyer is going to want a due diligence period to review the assets being purchased to make sure that everything is okay with it, that there's no major defects in that asset. So here's a really great opportunity, either side, whether you're the buyer or the seller, to sort of take advantage of the letter of intent to structure the deal favoring your side. So if you're the buyer, what you really want is to have a long due diligence period, as long as you can, and be able to terminate the deal based on your sole unquestionable discretion for any reason or no reason during that 30-day period. Now, the seller, on the other hand, is going to want to carve that out a little bit and cut that down. Going to reduce the time as much as possible, as well as reduce the ability of the buyer to get out of the deal and terminate the deal. So in that case, you may not want to have the buyer be permitted to actually terminate the deal for any reason or no reason. Perhaps you want to just have the buyer terminate the deal based on any material, environmental, or other major issues. And you could tailor that language appropriately. So that's one big spot for any party to get an advantage of if they properly frame this section of the LOI. Next, we say good faith deposit. Same situation here. Great opportunity for both the seller and the buyer to take advantage of structuring the LOI properly. So for a buyer, it's wise to separate the deposit into 2 or 3 possibly distinct time periods to deliver it. So the buyer would want to have maybe a small deposit, like we see in this example here, of $10,000 upon executing the contract, and then have a second deposit once the due diligence period ends, which is going to be the main deposit here of $178,000, which would equal about 10% of the purchase price. That way, they're protected in case the seller tries to take the deposit. So the seller will not be able to hold up that deposit. And if they do, it's only a smaller amount, $10,000, not a huge deal for this particular buyer. If you're on the other side and you're the actual seller, you obviously want to make sure that the deposit, as much as possible, the deposit gets placed into escrow up front before due diligence ends. Or before, I should say, a due diligence even begins, right after the contract is executed. We see another issue here, title. Not a whole lot of opportunity for either party to take advantage of. It's kind of standard. Title is going to be good title to premises and free of any liens. Closing, when to be held after, in this particular example, after expiration of due diligence period. Who's the broker? High-class commercial realty in this case. Confidentiality. Both sides want to keep this deal confidential. Expenses. Each party will be paying their own expenses. Again, you can tailor this if you want, one side or the other. If the buyer wants the seller to pay for certain things or certain expenses of the buyer, you can put that in here, and vice versa for the seller. Exclusivity. Okay, so here's an important one. And we're going to also take a look at an LOI and see the differences between both. But one of the major differences between an LOI and a term sheet is binding provisions. And in this case, exclusivity, the right of the buyer to essentially lock up the deal while they negotiate a contract for the next, in this case, 15 days, is a binding provision. And we see that really identified in the next paragraph, binding effect. So for LOIs, there will be a binding, usually there will be a binding, certain binding paragraphs. It won't necessarily mean that the deal has to go forward. Usually it won't require the deal going forward unless a further contract is executed and agreed to between the parties. But in this case, at least, the provisions of exclusivity and confidentiality are binding, and thus both parties have to adhere to those provisions and are essentially legally locked up and held to those positions throughout the term and exclusivity period. And you'll see here that it's obviously executed by myself as the person sending the LOI, as well as requesting the seller, the proposed seller, sign and execute the LOI to indicate an agreement of terms. Now we also have here an example term sheet, which is based on the same deal. Now the difference is mainly between term sheets and LOIs. They both cover the main deal points. However, they do it in certain different ways. An LOI is a little bit more formal. You'll see it more in higher end business deals. It's in paragraph form. It has some important binding provisions, and usually it's executed by both parties. Term sheet's a little bit more simplified. It's for simpler deals. It's bullet points. It's not usually containing any binding provisions, and for the most part, it's non-binding, and for the most part, it's a lot simpler or used for simpler deals. So I'll take a quick look at it. Again, this is the same deal as we just discussed in the LOI. Again, to Templeton Holdings regarding the purchase of 1500 Boulevard, Springfield Township, the name of the buyer, the purchase price, the deposit. Now you see here, again, the same thing, buyer or seller can take advantage of properly structuring the term sheet like this. Again, the buyer is structuring the deposit, $10,000 upon execution, and then the second deposit upon expiration of due diligence. Buyer require 30-day due diligence period, and then, of course, terminable at buyer's sole and questionable discretion. These are little things the buyer is putting in there, and of course, the seller can change that around or tailor it to their end as well, and either carve out or really, really constrict the efforts of the buyer here. So they can say that the deposit has to be all the way up front. They could say that they can terminate in due diligence only upon material, environmental, or other problems. And of course, like we discussed, mortgage contingency, title, who the broker is, when the closing is going to happen, and last paragraph here is just basically saying that this term sheet does not create any legal obligation or liability on part of either party, and is not essentially a binding contract, and that this is mainly used to set up the terms for a more formal contract to be signed to and negotiated later. And in this case, we actually do have the LOI being, the term sheet being executed by the other side, but you don't always have to have that. Bottom line here, guys, LOIs and term sheets are a very important opportunity to obtain an advantage in any business deal. If you have any questions or concerns, please feel free to connect with me on LinkedIn. Hope you enjoyed it and have a great day.